So very good evening all the participants. Today we'll discuss some of the case laws. So this PPT has already been shared with you and now also I have shared in the chat box. And I hope my screen is also visible to you. So first case is innovative. Now what innovative says? This is the case. I have cross-linked with the index. So innovative, Pradeep ji, please explain this case. This case is based on which section? First of all, so let it be in question answer format. This innovative industries, this is based on which section of IBC?
Section 7.
Section 7. Okay. Now, as you know, in CIRP, during CIRP, powers of the board stand suspended. But Supreme Court still entertained this appeal, although it was filed by the erstwhile directors. So why Supreme Court entertained this? Any idea?
I think this is first case, sir. First case
Right.
of the.
So this being the first case, so they said that okay, we are allowing it as a special case. Right? Now, what was the issue in this case? What is this Maharashtra Relief Undertaking Act? Any idea? What is this
Yeah.
Maharashtra Relief Undertaking Act?
Sir, this act grants moratorium.
Right, very correct.
So in this case, so state law versus no, central law. So which prevails over which? So that was discussed.
Right. This Maharashtra Relief Undertakings Act, as you know, there are three lists. What are the three lists? Can anybody tell me?
State list, central list, and union list.
Concurrent list. है ना?
Concurrent list, sorry.
So union list, state list and concurrent list. List 1 is union list, list 2 state list, list 3 concurrent list. IBC is covered under which list?
Concurrent list, sir.
And Maharashtra Relief Undertakings Act?
State
Is
list.
state list.
That is also in concurrent list. I just checked today. So it is in concurrent list only. So you can check on Google also.
Okay.
Although it is a state legislation, but the concurrent list says it covers legislations on which both the center and the state can legislate. So although it is included in concurrent list, but the law was made by the state. Similarly, IBC, although it is included in the concurrent list, but the law was made by the center. So, as per the rules of interpretation of statutes, if there are two laws, one is an earlier legislation, another is a later legislation, then later will prevail. Why? Because they believe that the lawmakers must have considered the earlier law also while framing the new law. Similarly, if a law is made by the state and a law is made by the center, then the law made by the center will prevail. And what is section 238? Section 238, anybody? Can anybody tell what is section 238? And what is the meaning? I hope my screen is visible. Is it visible?
Yes, sir.
Yes, yes.
Okay. So what is section 238?
Overriding provisions. Sir, that is.
Right. So section 238 says that the provisions of this code shall override the other laws. So it has got override effect. So this is something similar to non-obstante clause. So there are non-obstante clause in almost all the legislations. Like Income Tax Act also says something similar, that notwithstanding anything contained in any other law for the time being, enforce. That is what they are saying. Almost all laws. So whether this Maharashtra Relief Undertakings Act, whether that also had this non-obstante clause or not. This Maharashtra Relief Undertakings Act, which was relied upon by innovative industries, whether it also contained a non-obstante clause? Yes or no?
No, I think so.
Yes. It also contained. And IBC also contained this clause, non-obstante clause. So in both the acts, it was written notwithstanding anything. Now the question came, which one will prevail? So it says, if there is a conflict. This situation is called repugnancy. So in case of repugnancy, now what is the meaning of repugnancy? What is the meaning of repugnancy? You can read from point number 4.
Yes.
Yes.
Repugnancy means the direct collision with each other, reaching at a situation where it is impossible to obey the one without the disobeying the other. Conditional law, sir.
So it says that when one law must give way to the other. So this is the situation of repugnancy. So the two laws are at loggerheads. Both the laws are saying same thing. Then which one will prevail? So it says this happens when two enactments produce different legal results when applied to the same facts. So here in this case, this Maharashtra Relief Undertakings Act, it is basically a labor legislation. So it grants some sort of relief to the undertakings by virtue of which they are not obliged to pay for a certain period. So it grants some sort of moratorium. So this concept of moratorium was in vogue prior to IBC also. Moratorium in earlier legislations, it meant relief from non-payment basically. So here, this Maharashtra Relief Undertakings Act says that whenever an undertaking is sick, so there a relief is granted, say for a period of 1 year or more. At a time 1 year relief, and it can be extended also. Okay? So this is the situation. In Maharashtra Relief Undertakings Act. So now suppose there is some legislation which says that okay, you need not pay the liabilities. And then this IBC comes and section 7 application is filed. Then what will happen? This is the scenario in innovative industries. So when this ICICI Bank, which was the financial creditor, they filed an application, innovative industries took the plea that they are covered by Maharashtra Relief Undertakings Act, which grants them moratorium. So they need not pay despite default. This is the scenario. So Supreme Court dealt at length with these issues. Now what was the final finding of this case ultimately? What was the finding?
So
Ultimately, what was
ultimately,
the result?
IBC prevails over.
Right. So whether this application was admitted or not?
Yes, sir, admitted. Even though directors are not cannot make application because it's first case they admitted.
Right. So I hope now this case law is clear. Is there someone जिसको बिल्कुल भी समझ में नहीं आया ये वाला केस लॉ? क्या केस था ये? हाँ जी, हरीश जी समझ में आ गया? हरीश जी, आर यू देयर? हरीश बिस्ट जी,
सर सॉरी या थोड़ा थोड़ा
हैव
समझ
यू
में आया
अंडरस्टूड
सर, एक
दिस
बार स्टडी
केस?
करेंगे तो आ जाएगा, क्लियर हो जाएगा। एक बार सेल्फ स्टडी करेंगे तो ज्यादा क्लियर हो जाएगा सर, वैसे मोरलेस समझ में आ रहा है।
Okay, and B Sudarshanam ji, is it clear to you?
Yes, sir. Yes, sir.
Okay, so now let us go to the second case. So in this case, what are the questions they can frame? In the first case, they could frame the questions like in which case Supreme Court allowed the erstwhile directors who are no longer in management to file an appeal. Second is which case law talks of repugnancy. ठीक है? In non-obstetric laws, one of the first cases. Now second case, Mobilox Innovations. So this case is based on the definition of dispute. And definition of dispute, what is the section governing definition of dispute? In which section dispute is defined in IBC?
I think 8, sir.
No. I have already written the section on screen.
3, sir, I think.
Section I have already written on the screen.
Section 5, Section 8 and 9.
Section
5,
5, subsection
5,
6.
6.
Section 5, subsection 6 gives the definition of dispute. And it says dispute includes a suit or arbitration proceeding relating to the existence of the amount of debt, quality of goods or services, or the breach of a representation or warranty. So this definition of dispute is given in section 5, subsection 6. Now, what is the crux of this case? Sudarasanamuji, can you please explain the crux of this case? You can take help of screen also. So what was the case actually? Can you
Yes,
briefly explain?
Mobilax Innovative Industries had an agreement with the Kirusa Software for
Right,
this, what is that, Notch Bali program.
right, very correct. And there was a non-disclosure agreement
Uh,
also between
in the
these two
agreement, they
parties.
have mentioned that Kirusa Software should not disclose that thing to the public anywhere.
Right,
they have
very
disclosed.
correct. But despite this, Kirusa Software, they wrote on their website that they were working for Star TV.
Because of that, Mobilax did not pay the, when the
Right,
Kirusa raised the bill, they have not not made payment, stating
right,
that dispute exists.
right. So now what was the ultimate decision? What was
In
the
favor of
ultimate decision?
Mobilax. Mobilax in favor of Mobilax only, sir. Because
Right.
when
So they said dispute exists and IBC cannot be availed. You go to some other forum. If you have got recovery, if you want to recover money, you go to some other forum. IBC is not available because dispute exists. Existence of a dispute. Next case, State Bank of India versus V. Ramakrishnan and another. So what is this case? Pradeep ji?
Sir, this case talks about applicability of moratorium to personal guarantors.
Okay. So whether moratorium applies to personal guarantor or not?
No, sir, it's only applied to corporate debtor.
Okay. So which section says this thing?
Uh,
Section 14.
14, yeah.
So section 14, if we say, so section 14 says that this does not apply. Section 14, subsection 3b. So section 14, subsection 3b, if we says, it says the provisions of subsection 1 shall not apply to a surety in a contract of guarantee to a corporate debtor. So moratorium will have effect only against the corporate debtor. Now, what is the meaning that moratorium does not apply to personal guarantor? So what action can you take against personal guarantor during moratorium? What is
against
the
the
meaning?
personal guarantors, we can
We can
proceed.
invoke the
Anyone can proceed, even others
Right.
also.
So legal proceedings can be initiated or continued against personal guarantor even during the moratorium period. This is the meaning.
The personal guarantor is not immune to this section.
Right. Very correct. So personal guarantor is not covered by section 14. Section 14 3b specifically says so. Okay? So this is the case. Now you can go through the rest of the case. Next case, Pioneer Urban Land and Infrastructure versus Union of India. Now what is this case?
sir, इसमें तो home buyers are considered as financial creditors.
Right. No, that is there. So it's actually prior to this, what was the situation? Prior to this case, what was the situation? Whether home buyers were covered anywhere?
I think they were operational creditors.
No, they were not covered anywhere.
Yeah.
So, because lawmaker said that you have not provided any goods or services to the builder, so you will not be operational creditor. You will not be financial creditor because you have not given any loan to the builder. But this section, it included actually an amendment. So there was an amendment. So this effectively gave home buyers the status of financial creditors. ठीक है? Bankruptcy Code, Second Amendment Act 2018. Just a minute. And another RERA was also discussed here. So they said that the RERA and the code, they can coexist. So both the remedies are available to the home buyers. Even during IBC, they can approach RERA. And in case there is a clash, if there is any repugnancy between the two, then RERA must give way to the code. Okay. So it strengthened the rights of home buyers, which were earlier nowhere covered. They were neither treated as financial creditors nor operational creditors. So it recognized them as important stakeholders and it upheld the legislative intent. So it supported the government's move to provide home buyers legal recourse under the IBC, and it provided clarity on RERA versus IBC also. So it held that both can operate together, each having its own scope. Okay? So they said RERA is in addition to and not in derogation of the provisions of any other law for the time being in force. Okay? Also makes it clear that the remedies under RERA to allottees were intended to be additional and not exclusive remedies. Now, next case, ArcelorMittal India Private Limited versus Satish Kumar. What is this case?
But this talks about Section 29A, ineligibility for the resolution applicant.
Right. Actually, when this code came, Section 29A was not there. So whatever sections have capital A after that, like 29A, 32A, 240A, there are so many sections. 54A to P. So in all these sections, they were introduced later. They were not originally there. So this 29A also was not there. Okay? So it came afterwards. So here, which article of the Indian Constitution was used in this section? Because
142.
29A was not there at that time. So Supreme Court invoked which of the articles of Indian Constitution?
Article 142.
Right. So 142, it grants the Supreme Court the power to pass decrees or make orders necessary for doing complete justice. Suppose something is not written anywhere in the law, then whether Supreme Court can adjudicate? The answer is yes. Under which article? Article 142. It gives the Supreme Court the power for rendering of complete justice, so they can invoke the inherent powers. Now, what was the case actually? Here, the case was that ArcelorMittal India Private Limited and New Metal, they submitted their resolution plans. But RP found both ArcelorMittal India Private Limited and New Metal both ineligible. Okay? So in ArcelorMittal, it was found that AM Netherlands BV was declared as connected person in AMIPL. AM Netherlands BV has acquired 29.05% equity in Uttam Galva and has entered into a co-promoter agreement with other promoters of Uttam Galva. And Uttam Galva account was classified as NPA by Canara Bank and PNB. So Section 29AC says that if any account has been classified as NPA and 1 year has elapsed, so then that person or connected person cannot become a resolution applicant. So it was declared ineligible under 29A. Similarly, regarding New Metal, the point here was that, so Supreme Court said that this is the new law. So they said let one more opportunity be given to both ArcelorMittal and New Metal. So they say even if there is an NPA, they should pay. So it allowed them to pay off the NPAs of their related corporate debtors within 2 weeks of the Supreme Court judgment, failing which the corporate debtor would go into liquidation. Now also, as of now also, if an account is NPA, can a person become resolution applicant after payment? Now, what is the latest situation? Suppose a person's account is classified as NPA and he wants to submit a resolution plan. My question is, can he make the payment and become a resolution applicant? Yes or no?
Yes, sir.
Yes. Where it is written? It is written in 29 itself. So what it says?
After making payment, they may be eligible as a
Right.
result.
It says that the person shall be eligible. It is given in the proviso. 29AC proviso, provided that the person shall be eligible to submit a resolution plan if such resolution plan makes payment of all overdue amounts with interest thereon and charges relating to NPA accounts before submission of resolution plan. ठीक?
Sir, doubt है.
Yes, please.
All overdues interest they have told.
Yes.
Suppose 10 crores is the loan amount. 1
Right.
crore is the first installment overdue. That means only 1 crore is the overdue, and on 1 crore some interest may be there. If that person pays only 1 crore plus interest, whether he will be eligible or they have to close that loan account.
No,
The
no, it says actually, normally there is a clause that whenever there is a default, the entire amount will become immediately due. Normally, this is the standard agreement clause.
Suppose if they pay that overdue amount means normally account becomes standard. On such case also they may be eligible.
Yes. So, if anything is overdue, but normally what I am telling you is that in case there is a default, so there is a standard clause in almost all agreements that on the occurrence of the first default, the entire amount shall become due and the banker shall be entitled to proceed against the borrower. So by that way, they make all the amount as overdue. But your contention is correct. Whatever is overdue only that has to be paid along with interest and charges.
Suppose if that question comes in our question paper,
Yes.
this type of case
Only
law.
overdue. Only overdue. Whatever is written. Yes.
Okay, sir.
Right. Now next question. Committee of Creditors of SR Steel Limited versus Satish Kumar. So what this case dealt with various issues. So what were the issues before the Supreme Court in this case? Yes, please. What were the issues?
They raised so many questions, sir, regarding
Right.
the role of all.
Yes. These are the questions. I hope my screen is visible. So these were the various questions. And Supreme Court dealt at length with all these questions. First is regarding the role of RP. So what is the role of RP? To manage the affairs of the corporate debtor as a going concern. And he is also a key person who is to appoint and convene meetings of the COC. Another very important is to collect, collate and finally admit a claim. Okay. Now role of prospective resolution applicant. So it says it has a right to receive complete information as to the corporate debts owed by it and its activities as going concern prior to admission of an application under section 7, 9 or 10. For this purpose, it has a right to receive information contained in the information memorandum as well as the evaluation matrix. Role of COC, commercial wisdom. Okay. Jurisdiction of NCLT and NCLT. So it says that actually there are some judicial issues and there are some commercial aspects. So commercial aspects need to be taken care by COC and only judicial aspects can be seen by the adjudicating authorities. Okay. So there is no doubt whatsoever that the ultimate discretion of what to pay and how much to pay each class or subclass of creditors is with the COC. But the decision of COC must reflect the fact that it has taken into account maximizing the value of the assets of the corporate debtor and the fact that it has adequately balanced the interest of all stakeholders including operational creditors. So this being the case, judicial review would include judicial review that is mentioned in section 30 subsection 2 subsection E. Whether equality principle can be applied amongst secured and unsecured creditors for payment. So it says treatment should be equitable, and equitable does not mean equal. It should be equitable. Whether committee of creditors can constitute a subcommittee? Yes. For administrative purposes, they can constitute a subcommittee which will take care of routine matters, but ultimately the COC will be responsible. Next point is whether the plan can provide for extinguishment of rights of personal guarantors and whether such a term is binding on them. Yes, so claims of guarantors stand extinguished. So these were the issues. BK Educational Services Private Limited versus Parag Gupta. What is this case? What was the case actually?
This is about Limitation Act, I think.
Right. So it says कि if a debt is barred, so then whether application can be filed. Okay. And section 5 of Limitation Act was also referred to. What is section 5 of Limitation Act? Any idea? Section 5 of Limitation Act talks of condonation of delay. So if there is a delay, then delay can be condoned, which is given in section 5 of the Limitation Act. And it says whether section 238A as introduced by the Second Amendment Act operates retrospectively. So Supreme Court said yes. So it was the intention from the very beginning that Limitation Act will apply. So Supreme Court said that the code cannot be triggered in the 2017 for a debt which was time barred say in 1990. So that because when this IBC came, there was say some sort of doubt in the minds of the litigants that okay, these 3 years will apply from the inception of the code. But it is not so. So they said it will apply from the date of occurrence of the when the cause of action arises. So Supreme Court said that the code cannot be triggered in the year 2017 for a debt which was time barred say in 1990, as that would lead to absurd and extreme consequence. So debt due says it only refers to the debts that are due and payable in law. That is the debts that are not time barred. Okay? So Supreme Court said that the intention of the legislature from the very beginning was to apply the Limitation Act. Okay? So the judgment laid down a clear precedent that IBC proceedings are governed by the Limitation Act, ensuring that only legally enforceable, that is not time barred acts, can be subject of CIRP. So it prevented misuse of IBC for reviving old or dead claims. Next, Chitra Sharma versus Union of India. So what was this case? Chitra Sharma?
This is
Home buyers, I think.
home.
Yes, actually earlier when this IBC came, when this law came, so home buyers were not covered in the COC. Time was already over. 180 days were already over. So now this Chitra Sharma, she filed a writ petition in the Supreme Court, and it said that CIRP ignores the interest of vital stakeholders in building projects, chief among whom are individuals who have invested their wealth in pursuit of the human desire to own a home. So IBC in the submission of the petitioners recognized only 3 categories or classes: corporate debtors, financial creditors and operational creditors. So not being protected by the IBC, the petitioners contended that the rights conferred upon them by special enactments including Consumer Protection Act, by RERA could not be divested. Suspension of the right to seek redressal before an adjudicatory forum under section 14(1)(a) would, it was asserted, leave the home buyers without a remedy. Section 238 of the IBC gives it an overriding effect over other laws in existence. So here CIRP was initiated and 270 days were already over, and home buyers were not granted the status of financial creditors. Now Supreme Court said what to do now. So they said let the CIRP start from the very beginning, and you include home buyers also in the category of the COC. Okay? Supreme Court felt that in the facts of the present case, recourse to the power under Article 142 would be warranted to render complete justice. So power under Article 142 should be utilized at the present stage for the limited purpose of recommending the recommencing the resolution process afresh from the stage of appointment of IRP by the order dated 9th August 2017 and resultantly renew the period which has been prescribed for the completion of the resolution process. So they said that you include home buyers also. Okay? This was the case. Anuj Jain, IRP for JP Infratech versus Axis Bank. So what were the facts? What were the issues here? The issue was actually there
Of,
are two companies. One is
of a transaction.
right. One is JP Infratech Limited and one is Jayaprakash Associates Limited. So land parcel, it was within the JP Infratech. Okay? And loans were there in Jayaprakash Associates Limited. So the lenders of Jayaprakash Associates Limited were assured of their repayment, whereby the land which was owned by JP Infratech, it was mortgaged. So when CIRP of JIL started, JP Infratech started, so lenders of JL said, you also include us in the COC of JP Infratech. But Supreme Court said you cannot be included in COC of JP Infratech. And they said that this creation of security interest, it is also a PUFE transaction, section 43 transactions. Take it. So the question was whether this transaction, creation of mortgage interest, whether it is PUFE transaction, Supreme Court said yes, and whether the respondents, lenders of JL, could be recognized as financial creditors of the corporate debtor, JP Infratech, on the strength of mortgage created. Okay? So the Supreme Court said no. So lenders of Jayaprakash Associates Limited cannot be recognized as financial creditors of JP Infratech Limited. Okay? Swiss Ribbons versus Union of India. So this case was also a landmark judgment which answered various types of questions. Differentiation between financial and operational creditors, whether it is justified, Supreme Court said yes, it is reasonable and not discriminatory. Whether Section 12A is valid, it is constitutionally valid. Taken because it allows only with 90% approval to prevent misuse. Role of resolution professional. So it says it is not adjudicatory, it is administrative in nature. COC's powers. So regarding powers of COC, they said it is not, they are not arbitrary and they are. So court found that the commercial decisions of the COC are based on the collective wisdom of the creditors and are not subject to judicial review except on limited grounds. For example, if they are discriminatory or illegal. Okay? And whether IBC is constitutionally valid, the answer is yes. So these were the various general questions which were answered in Swiss Ribbons. Babulal Vardhanji Gurjar versus Veer Gurjar Aluminium. What was the case in this case? What was the issue involved?
I think the limitation period only.
Right. So it said whether Section 7 application, which is filed by the financial creditor, whether it is barred by limitation. This was the question. Actually, here the court answers only on the basis of the arguments you put forth. So in this case, the financial creditor said that the date of default is 8th July 2011. So once you mention that date of default is 8th July, so that means it is clearly barred by limitation because IBC came in 2016 only. And they said that 3 years have already elapsed. So Supreme Court said NCLT having not examined the question of limitation and NCLAT, they decided the question of limitation on entirely irrelevant considerations. Okay? So they said the NCLAT orders deserves to be set aside and the application filed by the respondent number 2 deserves to be rejected as being barred by limitation because on the limited ground that date of default was mentioned as 8th of July and there was no further argument on this. So Supreme Court said that Section 7 application was filed beyond the limitation period without any valid extension through acknowledgement or part payment. Hence, it was barred by limitation. Okay? So they said IBC is not a tool for recovery and mandated strict adherence to the 3-year limitation period. So it directs the tribunals to suo motu consider limitation wherever applicable, because this limitation act can be taken cognizance suo motu also by the courts, although even though the plea of limitation is not raised by the parties. Okay? So it strengthened the legal certainty for corporate debtors by disallowing stale claims from triggering insolvency. This was the case. Next case Sasidhar versus Indian Overseas. What was this case? Case Sasidhar versus Indian Overseas Bank. Actually, when this IBC came, the percentage for approval of resolution plan was 75. But later on, it was reduced to not less than 66. Now, in this case, the COC approved the plan with more than 66 but less than 75. This was the case. And NCLT, they ordered liquidation because COC did not approve. In the meantime, the settlement came. And then COC again approached that, my lord, now the percentage has been reduced to 66 and our plan was approved with more than 66 but less than 75. So now please reverse your decision. This was the case basically. Okay? So NCLT rejected the resolution plan and directed for initiation of liquidation process. NCLT held that in both the cases, the resolution plan did not garner support of not less than 75% of share. So the same stood rejected and thereby warranted the initiation of liquidation process. So now, what was the issue before Supreme Court? So Supreme Court said that the percentage of voting share, whether it is mandatory, now what is the role of RP, and where the amendment dated 6th of June 2018 regarding voting percentages prospective or retrospective. So these were the issues in the case.
Prospective, sir.
So they said this. So this, it says that the argument does not comment to us in that the word may is ascribable to the discretion of the COC. Okay? Because section 30 subsection 4 says कि may. In section 30 subsection 4 if we read, so the word may is used. So Supreme Court said that the word may is ascribable to the discretion of the COC. This argument does not comment to us. Okay? So argument is to approve the resolution plan or not to approve the same. Okay? So not less than 75 is important. And upon receipt of a rejected resolution plan, A is not expected to do anything more but is obligated to initiate the liquidation process. So Supreme Court said that COC is called upon to consider the resolution plan under section 34 after it is vetted and verified by the RP as being complied with all the statutory requirements. RP is not required to express his opinion on the matter, which is within the domain of the FCs. And it is within the domain of FCs to approve or reject the resolution plan. So Amendment Act will have prospective application and apply only to the decisions of COC taken on or after that date concerning the approval of the resolution plan. So they said you cannot apply it retrospectively. Okay? This was the case. Manish Kumar versus Union of India. What was the case here? Manish Kumar versus Union of India. सिंह साहब आप बताइए, एसपी सिंह साहब।
ये आइडिया नहीं इसके बाद।
यहाँ लिखा हुआ है, ये नजर आ रही है ना मेरी स्क्रीन आपको?
ओके, यस, फैक्ट्स।
हाँ, पढ़ लीजिए एक बार।
होम बायर्स का थ्रेशोल्ड लिमिट है।
राइट। सो
फाइनेंशियल क्रेडिट होम बायर।
So where it is written? It is written in
10% of total number of allottees or not less than 100 of allottees.
It is
whichever
given in
is
second proviso. So second proviso to section 7 subsection 1 says so that for financial creditors who are allottees under a real estate project, an application for initiating CIRP against the CD shall be filed jointly by not less than 100 of such allottees under the same real estate project or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So this was the case. Prior to that, this was not the case. When IBC came originally, this proviso was not there. So even a single home buyer could initiate IBC. And imagine, section 12A was also not there. Withdrawal was also not permitted. So they said, once CIRP has been, application has been admitted, CIRP has to take place. But then, considering the practical difficulties, these amendments came. So they said, a single home buyer cannot be allowed to disturb the entire project. So they said, let there be at least some minimum number. So what was that minimum number? 100 or not less than 10% of the total number of allottees into the same real estate project, whichever is less. Now another question came, what will happen to applications which have already been submitted and which have not yet been admitted? So Supreme Court said that okay, let those applications also be completed within a period of 1 month. Okay? So they said if within 1 month they do not fulfill this criteria, then the application will be deemed to be rejected. Okay? So they said that those applications under Section 7 which had not been admitted would stand withdrawn within 30 days if the newly declared minimum threshold of 100 allottees or 10% of the allottees, whichever is lower, was not garnered by the respective applicants. Now what was the ground of the petitioner? Petitioner said, भाई हम लोग 100 allottees कहाँ से लाएंगे, हम कहाँ से ढूंढ के लाएं, भाई एक दूसरे को तो जानते नहीं है, तो हम कहाँ से लाएं 100 allottees. बट सुप्रीम कोर्ट ने कहा कि भाई you have to adhere to this requirement. So SC further clarified that it does not matter whether a person has one or more allotments in the name of his family. So all independent allotments would qualify as separate allottees. ठीक है, मान लीजिए father and son both have applied in individual capacity, then they will be treated as two allottees and would be accounted for in the calculation of 100 allottees or 1/10 of the allottees. So it was then clarified that in case of a joint allotment to more than one person, the allotment is to be treated as a single. अगर joint होगा तो उसको single माना जाएगा, लेकिन अगर independent allotment है, separate है, तो separate allotments. ठीक है? This was the case. P. Mohan Raj and others versus Shah brothers. So what was the case here? In P. Mohan Raj and others versus Shah brothers, क्या केस था प्रदीप जी?
मॉरेटोरियम का है सर, वो चेक्स
Right.
नेगोशिएबल इंस्ट्रूमेंट.
Right. So it is based on the Negotiable Instruments Act. So the question here was, because for Section 14 grants moratorium, so whether during moratorium criminal proceedings can continue against the directors, this was the question. Because criminal proceedings or civil proceedings cannot be continued or initiated against the company. So far as company is there, okay, moratorium is there. But the question is, suppose a check is signed by a director, then can criminal proceedings under Negotiable Instruments Act, whether they can be initiated or continued during moratorium? The answer is yes. So they said that these are criminal in nature and they are not against the company, they are against the director, so they can continue. This was the case. So the issue was whether the scope of Section 14 of IBC would cover the magnitude of Negotiable Instruments Act and whether it is permitted to initiate the check bounce proceedings under the Negotiable Instruments Act or to continue the proceedings against the CD and its directors when the CD is about to resolve its bankruptcy issue or in an ongoing CIRP. So the decision was that Section 138 or 141 proceedings under Negotiable Instruments Act against a corporate debtor is covered by Section 14(1)(a). So you cannot proceed against the company. Okay? But moratorium, which is given in Section 14, would apply only to the CD. The natural persons which are mentioned in Section 141 of Negotiable Instruments Act, they continue to be statutory liable under Chapter 17 of the Negotiable Instruments Act. ठीक है, क्लियर है? चलिए नेक्स्ट केस, गुजरात ऊर्जा विकास निगम वर्सेस अमित गुप्ता एंड अदर्स. सो व्हाट वाज द केस हियर?
सर ये पावर परचेज अग्रीमेंट आई थिंक सर.
Right. So here actually this Gujarat Urja Vikas Nigam and Aston Field, so they entered into a power purchase agreement. Now the question is, because IBC proceedings were started against this Aston Field, and solely on this logic, Gujarat Urja Vikas Nigam Limited cancelled the power purchase agreement. They terminated the power purchase agreement solely on the plea that Section 10 proceedings have been initiated against Aston Field, Solar Gujarat. So the question was whether the clauses of power purchase agreement, whether they can be placed on a higher pedestal than the provisions of IBC. So it says power purchase agreement is an instrument within the meaning of section 238 of the IBC, because 238 gives overriding effect to IBC. And in the present case, the clauses of the power purchase agreement are inconsistent with the provisions of IBC. So NCLAT also held that Gujarat Urja Vikas Nigam Limited attempted to terminate the PPA on the sole ground that CIRP has been initiated against the corporate debtor. So the question is simply on this ground whether you can terminate the power purchase agreement. This is the question. So it was observed that during the CIRP, the RP has to maintain the corporate debtor as a going concern, and termination of the PPA would render the corporate debtor defunct. Then who will purchase this company? Aston Field Solar Gujarat Private Limited. Who will purchase this company if there is no power purchase agreement? Because as you know, whenever you generate solar power, it has to be given to some government authorities. So this Gujarat Urja Vikas Nigam was the authority, which was purchasing the power. And if that power purchase agreement itself is cancelled, then who will buy this Aston Field? This was the case. Arun Kumar Jagat Ramka versus Jindal Steel and Power Limited. What was the case here? Pradeep ji, any idea what was this case?
Sir, here also I think 29A is discussed.
You can read from point number 2.
So NCLT held that a person who is ineligible under section 29A of the IBC to submit resolution plan is also barred from proposing scheme of compromise and arrangement under section 230 of the Companies Act.
Right. So the point here is during CIRP or during liquidation, a scheme of compromise or arrangement could be proposed. So the question is, if a person is ineligible under 29A, whether he can propose a scheme or whether he can be a party to the scheme of compromise or arrangement. This is the case. So it said that a person who is ineligible under 29A, he is also barred from proposing a scheme of compromise or arrangement. This is the case.
Suppose if he is not ineligible, then I think he can.
Right, definitely. So the issue was whether in liquidation proceeding under IBC, the scheme for compromise or arrangement can be made in terms of section 230 to 232. The answer is yes. If so permissible, whether the promoter who is ineligible to file application, under 29A, whether he can file an application. The answer is no. So if a person, scheme for compromise arrangement could be made during liquidation also. 90 days period is the year. But the person is who can propose the scheme or who can be a party to the scheme. So they said this person who is ineligible, he cannot be a party to the scheme for compromise or arrangement. This is the case actually. Okay. 35(1)(f) also. So prohibition placed by the Parliament in 29A and proviso to section 35(1)(f) must also attach itself to a scheme of compromise or arrangement. Okay. What is 35(1)(f)? 35(1)(f), what 35(1)(f) says? Section 35(1)(f), if you see, what it says, that these provisions will apply during liquidation also. We got this 29A. 35(1)(f) says, subject to section 52, provided that the liquidator shall not sell the immovable and movable property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant. This is given in 35(1)(f). So 35(1)(f) says even sale cannot be made to a person who is ineligible under 29A. This case law says that a scheme of compromise or arrangement can also be put by a person who is ineligible under 29. This is the case. Next, Lakshmipad Surana versus Union Bank of India. What is this case? Yes.
And a financial creditor initiated insolvency proceeding against a corporate guarantor under Section 7.
Right.
5. The
Right.
principal borrower is not a corporate person.
Right. So this was the precise question, that in case the principal borrower is not a corporate person, whether Section 7 application can be filed against the guarantor. So Supreme Court said yes. And from when is the limitation period to be calculated? So this question of limitation was also discussed. And whether Supreme Court or whether any court can take suo motu cognizance of the limitation period, the answer is yes. Whether condonation of delay is necessary. So they said application for condonation of delay may or may not be filed. But what the court has to look into is what are the facts surrounding that application. So if there are sufficient grounds, then even though that formal application for condonation of delay has not been made, still delay could be condoned. Okay. So judgment clarified that corporate guarantors are independently liable under IBC even if the principal borrower is not a company. Financial creditors have the right to initiate CIRP against guarantors without first proceeding against the principal borrower. Okay. And another point was that although no formal application has been made for condonation of delay, still the Supreme Court can condone the delay. Next case देखिए, घनश्याम मिश्रा and Sons versus Edelweiss Asset Reconstruction Company. ये क्या केस था? घनश्याम मिश्रा. What was the case? Ghanshyam Mishra and Sons versus Edelweiss Asset Reconstruction Company.
So, sir, it is regarding the claims after approval of resolution.
Right. So once a resolution plan is approved, claims can be still entertained? This was the issue. So it says whether all claims, including statutory dues, suppose government department comes up afterwards, once the plan is approved. So whether the claims stand extinguished once a resolution plan is approved, and can any creditor, including government departments, continue to pursue claims not part of the resolution plan? So Supreme Court held that no creditor, including government authorities, can initiate or continue proceedings for claims which are not part of the approved resolution plan. And all such claims stand extinguished once the plan is approved. So in this case, ये पढ़िए जरा फैक्ट्स एक बार पढ़ लीजिए.
In Ghanshyam, Chopra and other similar matters, various tax authorities and government departments pressed their claim against the CD even after the resolution plan was approved by the adjudicating authority. A major issue was raised in relation to the claim that did not form part of the resolution plan. It was argued that such claim be permitted to be enforced even after the resolution plan was approved. In the matter of one of the connected matter, that is Edelweiss Assets Reconstruction Company Limited versus Orissa Manganese and Minerals Limited and others. The Honorable Ironclad, while dismissed the appeal, left it open for these creditors to press their claim before a civil court or appropriate forum. The Honorable Supreme Court has set aside the Ironclad finding and reiterated the law laid down in COC of SR Steel India Limited through authorized signatory versus Satish Kumar Gupta and others, wherein Supreme Court categorically held that once the resolution plan is approved, all claims stand extinguished and the CD is handed over to the resolution applicant RA as a fresh slate.
As a fresh slate, clean slate. Clean slate principle कहते हैं इसको.
Oh, yes.
So it says that statutory dues are not immune from discharge under IBC. Next, Pratap Technocrats versus Monitoring Committee of Reliance.
But actual metrics insolvency resolution process CIRP and insolvency bankruptcy code 2016 IBC was commenced against the Reliance Infratech Limited RIL wide order dated 15th May 2018 by National Company Law Tribunal. The pursuant to such an interim resolution professional was appointed and COC was formed on 24th May 2019. After due deliberation between the COC and prospective resolution applicant, the plan submitted by Reliance Digital Platform and Project Services Limited, successful resolution applicant SRA was approved by COC with 100% vote on 2nd March 2020. On the basis of its feasibility, viability and implementability, an appeal was filed under Section 62 of IBC by Pratap Technocrat and others appellant who are operational creditors of the corporate debtor before NCLT on the ground of unfair and inequitable treatment of COC and material
treatment of OC. OC मतलब operational creditor.
OC, sorry, treatment of OC, operational creditor, inequitable treatment of OC and material irregularity in accumulation and disbursal of fund. It was also argued that there was a haircut of 90%. Furthermore, it was contended that CIRP in itself was conducted in a secluded manner and the operational creditor were not made aware of the ongoing process. The appellant herein claimed that it has 90% of total operational debt and is a small and medium-sized company who has not been given due regard by COC.
Yes.
The application filed by Doha Bank and one FC was also brought at the stage of submission to raise the contention that many FC were excluded from COC. It was contended that NCLT failed to consider the implication of such exclusion of FC in the COC and that such exclusion resulted in increase the rate of recovery for FC from 10.32 to 91.98%. A contention was raised by the appellant that the realizable value of preference share held by the wholly owned subsidiary of the corporate debtor, namely Reliance Bhutan Limited in Reliance Realty Limited, was excluded from the liquidation value. It is pertinent to note that these preference shares were to be segregated and reserved for realizing rupees 800 crore for FC. As per the appellant submission, the apex court, however, noted that this was actually incorrect on the basis of valuation report submitted by the appointed valuer. Apex court verdict. On the application filed by Doha Bank, it was held that such application has no bearing on present matter and rejected any contention raised to the same.
With respect to the same.
With respect to the same. Okay. For the issue on the jurisdiction of approval of resolution plan, the apex court once again upheld the wisdom of COC and held that once an adjudicating authority is satisfied that a resolution plan has been approved in compliance with the provision of IBC and majority vote of the COC, the adjudicating authority shall mandatorily cease its jurisdiction, focusing on power and function of adjudicating authority under IBC. It was noted that it is creature of statute and is required to function within the realm of such statute only. In the end, the apex court upheld the COC wisdom, who approved the plan with 100% vote in present case, and noted that the adjudicating authority confined to the discipline and boundary of the statute and is only required to ascertain if a resolution plan meets the criteria under the IBC. Therefore, appeal was dismissed.
Yes. Next case. ABIC Singapore versus Committee of Creditors. So here, this is a case when pandemic came, when this COVID period came. So many resolution plans, they were pending before the adjudicating authorities. In the meantime, situations changed. So it says, suppose a plan is already approved by the COC and it has been forwarded to the adjudicating authority. And in the meantime, the resolution applicant feels that he wants to withdraw the resolution plan, whether it can do so. So Supreme Court said no. So once a resolution plan is approved by the COC and it is put forward before the adjudicating authority for approval, although adjudicating authority may take 2 years for approving the plan. So they said it cannot be withdrawn during that period. This is the case in a nutshell. So the case is, can a resolution applicant withdraw or modify the resolution plan after it has been submitted to the NCLT for approval, but before it is approved? So Supreme Court
can be withdrawn, no?
No, it cannot be. It cannot be withdrawn.
Before approval. Unless
before approval by adjudicating authority. COC has approved.
Approval or rejection both in both the case.
Right. So they cannot withdraw.
Okay.
So court rejected ABIC Singapore's request to withdraw its resolution plan. So it held that resolution applicants have no right to withdraw or seek modification once the plan is submitted to the adjudicating authority. This was the case.
So it should allow, because if the RA doesn't implement the plan, then what would happen?
Then liquidation will take place.
हाँ तो फिर मतलब ही नहीं है ना फिर तो.
नहीं, पर इसमें तो फिर सारे ही विड्राई करते रहेंगे ना. कोई कहीं देखो, लिटिगेशन की कोई फाइनलिटी भी तो होनी चाहिए ना. भाई, they give performance guarantee also. When they submit the resolution plan, they give a performance guarantee. They give a guarantee that if their resolution plan is approved, so they will submit the performance guarantee. तो वो तो गारंटी इन्वोक हो जाएगी ना फिर उनकी. ललित कुमार जैन versus Union of India. So what is the case? So a notification was there on 15th of November 2019. So by which personal guarantors to corporate debtors, they were brought under IBC. So they said, why this selective application? Why you are not notifying the entire part 3? You are notifying only the provisions relating to personal guarantors. So why this pick and choose? Why this selective application? So Supreme Court said it is allowed. They can do so. So Supreme Court said that personal guarantors, they form a distinct class. The court held that personal guarantors to corporate debtors have intimate connection with the corporate debtors' obligations and financial health. So classification is reasonable and based on intelligible differentia. So valid use of delegated legislation. So central government has the power under section 1 subsection 3 to enforce different provisions at different times, and this notification was a valid exercise and there is no conflict in liability. So court reiterated that the liability of the guarantor is coextensive with that of the principal debtor as per section 128 of the Indian Contract Act, and proceedings against the guarantor can continue independently even if the corporate debtor is undergoing CIRP. Next, Vidarbha Industries versus Axis Bank. So what is the case here? What is the case in Vidarbha? So in Vidarbha, actually Supreme Court said that they applied the rule of literal interpretation. What is the rule of literal interpretation? The rule of literal interpretation says that the lawmakers deliberately used a particular word for a particular meaning. Because section 7, the word may is used, and in section 9, the word shall is used. Even now, if you read section 14, in section 14, just if you read section 7, so section 7, subsection 5, what it says section 7(5)(b), it may by order reject, it may by order admit. Section 7(5)(a) says it may by order admit, and section 7(5)(b) says it may by order reject. So the word may is used. And if we read section 9, in section 9 subsection 5, the word shall is used. So this is the difference. So they said that the Supreme Court has deliberately said so. So they say in case of financial creditors, even if there is a default, still the adjudicating authority may reject the application. Okay? New Okhla Industrial Development Authority versus Anand Sonbhadra. So here the case is whether Noida Authority, which has given a leasehold land to a CD, whether it is a financial creditor or operational creditor. This is the question. So Supreme Court said that Noida Authority is an operational creditor and not a financial creditor. Because Noida Authority wanted to be included in the COC. This was the issue. So Supreme Court said that financial debt under section 5 subsection 8, it involves disbursement of money against consideration for time value of money. And the court held that there is no disbursement of money by Noida in this case. Simply granted leasehold rights in land does not constitute a financial transaction. Time value of money must be inherent. So periodic lease payments were not made against a loan or credit facility. The court emphasized that deferred payment obligations like lease rents do not by themselves create financial debt unless tied to a disbursed sum carrying time value of money. And Supreme Court said that Noida is not a financial creditor. Okay? Therefore, Noida cannot initiate proceedings under section 7, not participate in the committee of creditors as a financial creditor. ठीक है, चलिए नेक्स्ट केस बैंक ऑफ बड़ौदा वर्सेस MBL इंफ्रास्ट्रक्चर. क्या केस था ये, एक बार पढ़िए जरा. प्रदीप जी, कैन यू रीड दिस केस?
Yes, sir.
Yes.
So MBL Infrastructure Limited, respondent number 1 was set up by Mr. Anjani Kumar Lakotia in early 1990s. Loan credit facilities were obtained by respondent 1 from SBI as a lead bank. On the failure of respondent 1 in terms of repayment, some of the respondents, a consortium of banks, were forced to invoke personal guarantees extended by respondent number 3. That is State Bank of Bikaner, Jaipur, merged with State Bank of India, with RBL Bank having issued notices under Section 13 of SARFAESI Act 2002, followed by Allahabad Bank and State Bank of Bikaner and Jaipur. RBL Bank filed an application to initiate CIRP against respondent 1, leading to moratorium and an additional 90 days of CRP. Two resolution plans were received by RP, one authored by respondent 3 prior to the introduction of section 29A of the IBC. The IBC Amendment 2017 introduced section 29A to the code. Respondent number 3 filed an application for a declaration that he was not disqualified from submitting a resolution plan. The adjudicating authority ruled that there is no disqualification per se under section 29A(h) of the code, as liability under the guarantee arises only upon its invocation. Respondent number 3 could not be considered as a defaulter for breach of the guarantee. Respondent number 3 filed an application invoking section 60 of the code, and further amendment to section 29A(h) came into effect on 18 January 2018, which states that a person is not eligible to submit resolution plan if they have executed an enforceable guarantee. Argument advanced by the appellant. Respondent number 3 was ineligible to submit resolution plan under section 29A(h) of the code due to several personal guarantees signed in favor of different creditors of respondent 1. The adjudicating authority ignored this information on both occasions, and even respondent number 2 was unable to present it. This means the presumption used by the adjudicating body to determine that respondent 3 was qualified to submit a resolution plan is initially false. Section 29AH and 30 subsection 4 must be interpreted using the same analogy, meaning the disqualification become effective as of the application date. Fraud taints all solemn acts, so the appeal should be granted. Legal ineligibility cannot be removed by alleged estoppel. The appellant tribunal's order confirming the adjudicating authority's decision must be set aside as appellant was not a party before it on previous occasions. Argument advanced by the respondent. This court doesn't have to intervene in a decision made by the COC to be satisfied with the expert's report on the viability and feasibility of resolution plan. The revised plan approved by the appellant tribunal is an improvement over the original one provided by the respondent 3. The court's objective must be read in conjunction with section 29A. The appellant is restrained from contesting respondent number 3's eligibility to submit a resolution plan in accordance with section 29AH, meaning that a personal guarantor is only prevented from submitting a resolution plan when the creditor using the adjudicating authority's jurisdiction has used a personal guarantee that resolution applicant had executed in their favor. While Allahabad Bank and State Bank of Bikaner and Jaipur's use of consortium guarantee under section 13 subsection 2 of SURFACE Act is an ex failure because of inter se agreement between the members. RBL Bank didn't invoke a personal guarantee. Before the adjudicating authority, neither Allahabad Bank nor State Bank of Bikaner, Jaipur submitted an application. The counsels for the respondent have sought to reply on the decisions of Swiss Ribbon Private Limited, KN Rajkumar, ArcelorMittal India Private Limited, and the Committee of Creditors, SR Steel India Limited.
So now the point here is, I hope you have understood the case. The case is that a guarantor has given a guarantee for a loan. Okay? But the initiation of application under section 7 is not made by that person to whom the guarantee was given. The application was moved by RBL Bank, and the Sanjani Kumar Lakhotia, who was a resolution applicant, he did not give RBL Bank any guarantee. So the question is on the interpretation of 29AH. So 29AH, what 29AH says? That if a person has given a guarantee and that guarantee has been invoked and it remains unpaid and the financial creditor initiates application under IBC. Okay? So the point here is that if the insolvency was triggered because of the furnishing of the guarantee and its invocation and its remaining unpaid, only then that person becomes ineligible. This is the case. Next, state tax officer versus rainbow papers. What is this case? What is
This
this judgment? Very important judgment.
statutory dues.
Actually, it is a judgment on the creation of security interest. So they said that this Gujarat VAT Act, it creates right in favor of the Gujarat VAT authorities. That in case, suppose a person is registered under Gujarat VAT Acts and he has got VAT dues which he does not pay. So it says the Gujarat VAT authorities, they have a charge on the security of the assets of that person who has not paid the VAT dues. And this is written in Gujarat VAT Act. So it says that Gujarat VAT authorities become a secured creditor. Okay? And it said that the creation of security interest could be by virtue of law also. Okay? And they said there was no obligation on the part of the state to lodge a claim in respect of dues which are statutory dues, for which recovery proceedings have also been initiated. So they said there is a statutory charge in terms of section 48 of the Gujarat VAT Act. The claims of the tax department of the state squarely falls within the definition of security interest under section 3 subsection 31. So section 3 subsection 31 gives the definition of security interest. So they said state becomes a secured creditor under section 3 subsection 30. So such security interest could be created by operation of law also. So they said if Gujarat VAT Act says that the supplier will become a will be liable for the security, and so Gujarat VAT authorities will become a secured creditor. So they said such security interest could be created in favor of Gujarat VAT authorities by operation of law also. Okay? And the definition of secured creditor in the code does not exclude any government or governmental authority. Okay? Next case, Asset Reconstruction Company India Limited versus Tulip Star Hotels. So what was the case here?
I think Limitation Act.
Actually, Tulip Star Hotels Limited, they challenged this application which was filed by Asset Reconstruction Company India Limited. So they said that a dispute exists. Okay? And questions surrounding the nature and enforceability of the debt. So the question was whether ARCIL claim is a valid financial debt under section 5 subsection note, and could the existence of pending civil proceedings or disputes bar the admission of a section 7 application? Because the question of dispute comes in section 9 application and not under section 7 application. And what is the scope of inquiry under section 7 while admitting a CIRP application? So these were some of the questions. So what Supreme Court said? So Supreme Court said that under section 7, the adjudicating authority must only examine the existence of debt and default. Unlike section 9, disputes are not relevant for financial creditors at admission stage. And existence of civil proceeding is not a bar. So even if a civil proceeding is subsisting, still section 7 application can be filed. So pendency of suits or arbitration proceedings does not prevent the admission of a section 7 application. So IBC provides a summary remedy and civil litigation does not override this special mechanism. So debt was valid and enforceable. The court held that ARCIL had established a valid financial debt which arose from financial facilities, and debt was due and payable, and there was no bar under law to its enforceability. So decision was that section 7 application can be maintained despite civil proceedings. Okay? So it clarified that Section 7 focuses solely on debt and default, not broader commercial disputes. Next case, Sundaresh Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs. So please read this. Singh
The
साहब आप पढ़िए जरा.
The Supreme Court observed that once the moratorium is introduced, either under Section 14 or Section 33, subsection 5 of Insolvency and Bankruptcy Code 2016, the authorities under the Custom Act 1961 Custom Act have limited power to the extent that they can only initiate assessment or reassessment of the duties and other levies and cannot initiate recovery proceeding. Brief
So
fact.
actually, Section 14 says that you cannot initiate recovery. Assessment can continue. In
Right.
income tax also, same is the case. Assessment can continue, reassessment can be done, but there cannot be any initiation
Recovery
of
proceeding.
recovery proceedings.
ABG Shipyard Corporate Debtor is a company in the business of shipbuilding and thus regularly imports various materials for the purpose of constructing ships. Some of these goods were stored by the corporate debtors in custom bonded warehouse in Gujarat and container freight station in Maharashtra. When corporate insolvency resolution process CIRP was initiated against the corporate debtor by the order dated 2nd August 2017 passed by the National Company Law Tribunal, Ahmedabad. Thereafter, the interim resolution professional appellant on 21st August 2017 sought for the custody of the warehouse goods from the Central Board of Indirect Taxes and Custom respondent and requested them not to dispose of or auction the same. Thereafter, from 29th March 2019 to 7th April 2019, the respondent issued 5 different demand notices to the corporate debtor, raising a total demand around 15 crore 80 lakhs.
Just a minute.
Oh.
So the point is whether you can initiate recovery during moratorium. This is the issue. Yes. So issues, you can directly read from the issues part. Or you can directly jump to the decision. Decision पढ़ लीजिए सिंह साहब. नजर आ रहा है ना? हाँ जी.
Sorry, sir.
Visible है ना? Is it visible?
जी, sir.
Yes.
The respondent then filed an appeal before National Company Law Appellate
नहीं,
Tribunal.
decision पढ़ लीजिए सिंह साहब. Decision
Okay.
directly. हाँ जी.
Okay. The Honorable Supreme Court for the first issue noted that the Custom Act and IBC act in their own sphere. However, a bare perusal of Section 142A of Custom Act provide that the custom authority would have first charge on the assets of an assessee under the Custom Act, except with the respect to cases under Section 529A of Companies Act 1956, recovery of debt due to banks and financial institutions Act 1993, securitization and reconstruction of financial assets, and enforcement of security interest Act 2002 surfacing, and IBC 2016. Such an exception created under the Custom Act is also acknowledged under Section 238 of IBC, wherein overriding power is given to IBC against any other law that may be inconsistent to it. Another reason for IBC to prevail over the Custom Act observed by the Supreme Court was that the IBC, being more recent statute, clearly override the Custom Act. Further, the Supreme Court observed that prior to IBC, different institutes were resulting in parallel proceeding, and one of the objectives behind the enactment of IBC was to end the conflict between the different institutes.
Yes.
Clear.
So this was the case. So case क्या था? सो सुप्रीम कोर्ट ने कहा कस्टम्स एक्ट में अपने आप ही एक्सेप्शंस दे रखी हैं फॉर कंपनीज एक्ट, आरडीबी एक्ट, सरफेसी एंड आईबीसी. सो ओवरराइडिंग इफेक्ट इज गिवन टू आईबीसी. ठीक है ना. आईबीसी मीइंग मोर रिसेंट स्टैट्यूट क्लियरली ओवरराइड्स द कस्टम्स एक्ट. है ना. सो नेचुरली यू कैन नॉट इनिशिएट रिकवरी प्रोसीडिंग्स. इतना ही करते हैं आज, काफी हो गए है ना.
ओके सर, थैंक
बाकी
यू.
कल करते हैं इसको. हाँ,
यस.
एक बार पढ़ लीजिएगा सारे
ओके
केस
सर.
लॉस, है ना. अपने आप एक
ओके.
बार पढ़ लीजिएगा. तो फिर भी
ठीक
चलो
है.
कुछ अच्छा डिस्कशन हो गया, कुछ तो पता चला, ऐसी बात नहीं.
जी जी.
हाँ जी. ओके.
ओके सर, थैंक यू. गुड नाइट.
गुड
गुड नाइट.
नाइट.